accused, what's my response to this? I should read it again. Now listen again. This is an insinuation from the defense counsel that the accused is saying that he does not understand the last charge, the last count charge, the last count charge read to him. It will be for the interest of justice for the accused to actually inform the court whether he understands or does not understand. If actually he does not understand, that means that it is the responsibility of the JA to also read it again to him. If it requires explanation, he can as well explain. So when we want to hear from the accused person, if you don't understand, tell the court that you don't understand. Because you can only take your plea on a charge that you understand. Are you hearing me?
Yes, sir.
So, having read this count 3 to you, tell this court, do you understand the charge, or should I read it again that you don't understand? You understand the charge?
Yes, sir.
Okay. Having informed the court that you understand the charge, how do you plead? Guilty or not guilty on that charge? They are giving you another leverage, another time, another opportunity to make your plea. Because this is a proceedings for change of plea. If actually you want to change your plea in this charge, you have told the court you understand the charge. Is it not?
Yes, sir.
How do you plead to this charge? Guilty or not guilty?
Guilty, sir. Should never justice be necessary.
Okay. Thank you, Your Lordships, distinguished members of this Honorable General Court. The charge has once again been read to the accused person. 3 count charges read to the accused person. And in line with the proceedings for change of plea, that's to enable him to change his plea. He has successfully pleaded guilty to the 3 count charges. It's now left for the court to deliberate and as well to go deliberate on the change of plea of the accused person. And as well, having studied the countenance of the accused person, his demeanor in the process, in the proceedings of change of plea, should be able to determine whether to accept the plea of change of plea that he made or not. It boils down to the court, in line with the rules of proceeding. I humbly request the court to go for deliberation and as well come back to inform the court whether they will accept the change of plea or not. Prosecution, do you have anything to say?
Just for record purpose and to be seen as justice is not only done, but is manifestly done. And my lords, reading through there's naval court-martial's procedure for Royal Navy, the provisions is similar to what are obtained in the rules of procedure, and they need to explain to the accused person the implication of his plea of guilty, the likely punishments that are waiting, and the fact that the court will go ahead to enter even the maximum punishment provided in the Armed Forces Act. And the procedure, although I think it's fairly important that these are explained on record to the accused person before before the court will try to deliberate and to come up with a decision whether to accept the pleas or not. That's my humble observation.
Defense, any response to that?
Yes, my learned senior has said it all, to have the record straight. But that is what the rule says. In the rule of the court, I don't think we have to exercise discretion. So let's exhaust it. That's our humble observation.
At this point, the accused person has actually pleaded to the 3 counts charge. It is incumbent on the judge advocate, in line with the rules of procedure, Royal Navy BR 11, which is synonymous to that of rules of procedure Army 1972. It states that wherever the accused person pleads to the charge, guilty to the charge, it is the responsibility and incumbent on the judge advocate to explain the implication of his change of plea. The implication of his change of plea, and again the discretion of the court to go, the discretion of the court to go ahead and enter judgment in line with his plea of guilty. The accused, now I'm addressing you. You have made a change of plea to the 3 count charges which was read to you. It implies that you have given the court, you have asked the court to go ahead and deliberate on whether to accept the plea on the ground that they have the power to go ahead as well to punish, enter any judgment. The implication is that you have submitted yourself for judgment. You are asking the court to enter any judgment, even when the court decides to enter the maximum judgment against you, that it is what you have accepted by faith. And of course, the court has the discretion as well to put into consideration the fact that you have all as well pleaded guilty to those offenses. So, the court will go for deliberation, and when they come, as well, they will as well consider to accept or not to accept. Where the court accepts their change of plea of guilty, they will enter judgment, and whatever they enter as a judgment, you accept it because you have pleaded guilty to the all count charges. When the court refuses to accept, it means that they are going to go for full trial, and it now the onus will now be shifted to the prosecution to call their witnesses. And the implication is that they are going to go for full trial, and when they go for full trial, they will call their witnesses to testify against you. And when they do not go for full trial, it means the court has the power to enter judgment, and that you will have to bear the liability of the punishment. Do you understand? The court should go ahead, deliberate, and come back that you are accepting, you have agreed, as you pleaded guilty to the 3 count charges. Now you are not in duress, you are not under influence, that it is your wish that you accepted this plea of guilty that you pleaded on the 3 count charges.
Yes, sir.
Thank you. The Lordship is now for the court to go to inner chambers for further deliberation and to come out with a conclusion on whether to accept the plea of guilty or not. Please, thank you.
All right. At this point, the court will rise to
to go and deliberate on the accused written change of plea. When we return, we'll give our ruling. Alright. Thereafter, the defense counsel submitted that the accused written may have committed the offense as a result of his inexperience in service, looking at the number of years he spent in service, which was nearly 4 years as at the time of the commission of the offense. He further pleaded with the court to consider the adverse effect of the punishment to be awarded to the accused written by this court. However, in all of the submissions of the defense counsel, in his plea of mitigation, this court consistently observed that the countenance of the accused written is more of unremorseful and unapologetic. The accused written attitude of disobedience to lawful authority, which was indeed similar to one of the count charges which he faced in this criminal trial, continued to manifest even while the procedure was ongoing. It is therefore out of the principle of justice and fair trial that this court accepted the accused written change of plea. However, this court will not be deterred from ensuring that justice is meted out in this case. One can only imagine the action of the accused written when he disobeyed the order of a senior officer and yet blatantly resisted arrest and still went as far as expending 16 rounds of 7.62mm special. What agitates the mind of this court is that the action of the accused written could have resulted to the death of any of his colleagues, which could have occurred from his sporadic shooting. The action of the accused written is no doubt an act of gross indiscipline, capable of taking the lives of his colleagues. It is now evident that the accused written, by his action, can never be trusted with rifle in the armed forces of Nigeria. And if so, it therefore means that as a rating in the Nigerian Navy, who cannot be entrusted with rifle, there is no doubt that he will not be useful to the Nigerian Navy and indeed the armed forces of Nigeria anymore, since soldiers rating and aircraft made are trained for the purpose of weapon handling and judicial applications when called upon for the protection of the sovereignty of the Federal Republic of Nigeria. Consequently, this General Court Martial find the accused written guilty on the 3-count charges as he earlier pleaded. This court thereby sentenced M5759 Seaman Abbas Haruna as follows. Count 1 on disobedience to particular orders, reduction in rank from seaman to ordinary seaman. Count 2 on resistance to arrest, dismissal with enormity from the armed forces. Count 3 on offense in relation to public and service property, dismissal with enormity from the armed forces. However, counts 2 and 3 shall run concurrently. This judgment is, however, subject to confirmation by the appropriate superior authority. This judgment is dated this 7th February 2022.
We shall not bet. Thank your industry and your magnanimity, even though in your sentence. We say we're very grateful, and may the Almighty continue to guide you as you continue your other deliberations. That's our appreciation.
The prosecution.
My Lord, we very much appreciate the court for the industry and the well-balanced judgment and sentence. It will go a long way to send a message, strong one, to any other would-be offender. My Lord, on this note, we want to most respectfully announce that that's the end, the only case, at the end of the cases we brought before this General Court Martial for today and for the time being, and maybe subject to the overriding decision of the conferring authority, the court may adjourn sine die. Thank you, my Lord.
Okay, having to tell the cases that are presented before this court for the time being. This court is hereby joined indefinitely. So